Welcome to the 2018-2019 Granite School District Section 504 training. This training will discuss what educators need to know and do in regards to Section 504, and will include a review of the referral process, the eligibility process, and best practices. Let's start by reviewing the content and language objectives for the training. Participants will gain an understanding of the Section 504 requirements in school settings and be able to apply knowledge to implement the 504 referral and planning processes. Section 504 of the Rehabilitation Act is an anti-discrimination law providing protections for students who are determined eligible. All schools in our district accept federal funds, therefore this law applies at all Granite School District schools. Section 504 went into effect in 1973, 2 years before special education law, known as IDEA, were passed. Think for a minute about all of the activities that take place in your school, including academics, opportunities on school grounds, off school grounds, but are school sponsored, after school programs, field trips, clubs, school sponsored trips. If you have specific types of other school-sponsored activities, think about those as well. After-school programs that are operated by other agencies may also be considered school-sponsored activities. When you think about all of the activities associated with school activity and school settings, you need to think about who might be eligible for Section 504 services and accommodations. There are 2 criteria for meeting the obligation under Section 504 for eligibility. A student must both have a disability as defined under 504 and also qualify under Section 504. And we'll discuss the specifics of all of that in this training as we move through it. A student with a disability is defined as any student who has a physical or mental impairment which substantially limits one or more major life activities in the school setting or school-sponsored activities. So let's define this a little bit more specifically. Physical or mental impairments under Section 504 can be defined in several ways. But keep in mind that the things that we're going to review here in this presentation are not an exhaustive list. There may be other conditions not listed that could substantially limit one or more major life activities under the definition of eligibility for Section 504. Any physiological disorder or condition, cosmetic disfigurement, or anatomical loss affecting one or more of the following body systems: neurological, musculoskeletal, special sense organs, respiratory, including speech organs, cardiovascular, digestive, genitourinary, hemic and lymphatic, skin and endocrine, or any mental psychological disorder, such as intellectual disabilities, organic brain syndrome, emotional or mental illness, and specific learning disabilities. Do you notice how, under Section 504, the terms are similar to, but not identical to, the categories listed under the IDEA? Keep in mind that while Section 504 and the IDEA have some similarities, there are very specific differences that are defined in the law, and we'll touch on those later. Also, remember again that these are samples of potential issues that a student may be facing in terms of mental or physiological or psychological disorders that would qualify you under 504, and it is not an exhaustive list. Now let's define the term substantially limits. This phrase is not formally defined in the Section 504 regulations. However, guidance documents from both the Office of Civil Rights, OCR, and Department of Justice have provided the definition they use when monitoring, investigating, and processing issues regarding eligibility or adherence to 504 regulations. So we accept the definition that the Department of Justice offers out of the rules that they have constructed as the specific definition of 504. In 2016, the Department of Justice adopted 9 rules of construction to assist teams in determining whether impairments are substantially limiting in major life activities. So this is the definition we will use for substantial limitation or substantially limiting a student's access to major life activities. Okay, so let's talk about the definition of substantially limiting. There are 9 rules that the Department of Justice kind of follows. Throughout these, you'll see an overall theme that becomes apparent in these guidance documents, as well as in case law since amendments went into place in 2009. Teams should not try to limit eligibility. Rather, teams should look to potentially find students eligible broadly and assume that a need is there, and the investigation should be undertaken to determine whether or not they qualify, versus waiting for a burden of proof that a student has a disability that limits them. So make sure that teams are looking at Section 504 broadly and are open to potentially finding students versus guarding Section 504, if that makes sense. So let's go through these. Substantially limits is not intended to be a demanding standard. Okay, so think about that against the IDEA. We have a pretty demanding standard under the IDEA. In fact, we have very specific criteria under each of the 13 categories under the IDEA that a student needs to meet. And then we also have 3 prongs. This is not as demanding a standard as we find under the IDEA. Determining whether an impairment substantially limits should not demand extensive analysis. Again, in contrast to the IDEA, where we require extensive analysis, this analysis should not be extensive. There should be information that you have. There should be medical documentation, perhaps, or there should be other data that has been gathered for analysis, but it is not necessarily extensive. Impairment does not need to limit more than one major life activity. Impairment does not need to prevent or severely restrict an individual to be substantially limiting. In terms of number 4, we need to ask the question how the impairment limits the individual's ability to perform the major life activity as compared to most people in the general population. And then number 5, an impairment that is episodic or in remission qualifies if it would substantially limit a major life activity when active. Determination of whether an impairment substantially limits a major life activity requires an individualized assessment. Okay, let's move on to number 7. The individual with an impairment or the parents of a student with the impairment does not need to produce scientific, medical, or statistical evidence of impact on a major life activity. Also, public entities, which are our schools, may not consider the ameliorative effects or the positive effects of a mitigating measure, something that helps to make the impairment better, when determining whether an impairment substantially limits major life activities. Okay, so thinking about that, we cannot consider the positive effects of something like medication when we're determining whether or not a student is eligible, because we need to look at what would happen if the student did not have that mitigating measure and was not benefiting from that mitigating measure. So really we have to look at what a student looks like when they have the mitigating measure and when they do not, when we're determining eligibility. Okay, so that's really important to think about, because you may not be necessarily aware of a student's impairment if the ameliorative effect is so positive that it doesn't regularly manifest as something that has a major life activity impact. Okay, so take time to consider episodic issues. If a student has a day where suddenly the behavior is different than another, and you come to find that student's on medication, do you need to think about whether or not that student may have an impairment that substantially limits? Finally, number 9, the effects of an impairment lasting or expected to last less than 6 months can be substantially limiting within the section of establishing presence of impairment. So thinking about temporary impairments, injuries, post-surgery healing, etc., may need consideration for eligibility under Section 504. The 6-month timeline is a guideline and not a hard and fast rule. If the impairment is anticipated to last less than 6 months, the school team would most likely not need to determine eligibility under 504 and would provide accommodations for the student to participate as they are able informally. If the condition or impairment is anticipated to last longer than 6 months, the team would want to consider whether the student has a disability that is substantially limiting one or more major life activities, and consider whether a Section 504 plan is needed to accommodate the student's needs. Temporary disabilities and any plans developed should be reviewed when the condition changes to either add new accommodations or to discontinue the plan and eligibility. Okay, now let's talk about the definition of major life activities. So these are defined as functions such as caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working. Additional functions we must consider: eating, standing, lifting, bending, reading, concentrating, thinking, and sleeping. Schools are reminded that this is never an exhaustive list. OCR has also warned schools not to limit their evaluation inquiry to the major life activity of learning. While schools are central to learning, and that is our focus, we need to consider all of the major life activities that may be substantially limited by an impairment. Needing accommodations for food allergies may or may not affect academic progress, but may affect other aspects of major life activities. These students may be eligible, but may or may not require accommodations while at school. Therefore, potentially may or may not require a 504 plan. You hear a little bit of the irony in this. You need to think carefully and individually about whether a student needs a 504 plan. Allergies may require one. Allergies may not, depending on whether or not they need accommodations while at school. This is something that each team needs to consider carefully when they look at all of the major life activities that may be substantially limited. Another category for definition is major bodily functions. These are included to, but not limited to, functions of the immune system, bowel, brain, endocrine, normal cell growth, respiratory, digestive, neurological, and circulatory systems. Keep in mind that with this list, these are just examples, and other conditions may also exist that would meet the eligibility criteria. And again, these may or may not require accommodations or services associated with Section 504. That is for the team to determine. So we have defined some of the main terms under Section 504 that we run into when we're looking at evaluation and implementation of Section 504 plans. Now we're going to talk a little bit about evaluation specifically under Section 504. A school must conduct an evaluation of an individual who, because of an impairment, needs or is believed to need additional services and supports than what is provided in the school setting typically. The decision to conduct an evaluation is governed by the individual circumstances in each case. Remember that the process of evaluation under Section 504 is not necessarily the same intensity as evaluation under the IDEA, as we discussed earlier. Under Section 504, we are gathering enough data to determine if there's an impairment and if that impairment is substantially limiting one or more major life activities in the school setting or during school-sponsored activities. The IDEA, again, has a very prescribed process and specific criteria assigned to each of the 13 categories under IDEA. Okay, so specifically, Section 504 requires the use of evaluation procedures to ensure that children are not misclassified, unnecessarily labeled as having an impairment, or incorrectly placed based on inappropriate selection, administration, or interpretation of evaluation materials. Evaluation does not necessarily mean test in the Section 504 context. Evaluation refers to a gathering of data, of information from a variety of sources so that the committee can make the required determinations. A medical diagnosis is not required for Section 504 eligibility. No medical evaluations are required unless the district decides that such evaluation is needed. If the team determines that a specific type of evaluation is needed, that evaluation must be provided at no cost to parents. Once a team has determined that evaluation is required, the type and amount of information needed is determined by the multidisciplinary committee or team. Enough information to make a knowledgeable decision as to whether or not the student has an impairment is all that is required. The committee should include persons knowledgeable about the student, the meaning of the evaluation data, and placement options. These might be people like nurses, school psychologists, social workers, could be personnel from outside if the parent believes that they would like to bring someone in as well. The team determines what data already exists and what, if any, additional data may be necessary to determine eligibility. If additional data are needed, the team must develop a plan to collect the needed information in a timely manner so that determination of eligibility under 504 is not delayed or denied due to a lack of information. So this needs to be a reasonable amount of time. It needs to be quick enough so that you know that the student is getting what they need in the school setting so that they have access to their education. The committee must include parents. The additional committee members should be determined based on the types of needs the student has. Those additional members would include at least one teacher, more if appropriate. Other types of service providers such as the counselor, social worker, psychologist, nurse, as I discussed, or also could include an occupational therapist, a physical therapist, a speech language pathologist, or others as determined necessary by the team. The next two slides include sources of information and factors to consider in the evaluation process. Again, this is not an exhaustive list of sources of information and factors to consider, nor does every factor or source lead to a decision that must be made regarding a student's potential impairment. So what I mean by that is you may have a student who has attendance records that look pretty bad, and that may or may not be a source of information and a factor to consider when considering eligibility for 504. You need to look at one source of information and one factor in conjunction with all of the other sources of information and factors to make an individual decision. So let's go through this quickly. Reports from teachers, nurses, parents, and other knowledgeable personnel about the student. And this could include outside medical diagnoses, and it could also include outside observations or other information that they have from the outside. Observations by teachers and other professionals, attendance records, assessment scores, student grades and progress reports, progress monitoring data, and student work samples. These are all data sources that you should consider and look at when you're evaluating a student under Section 504. It will help you to have a more comprehensive view of the student that may have just come to you with one very specific concern or one very specific identified need. Looking at a broader range of data points helps you to look at the student, the whole student, and determine if there is more or other factors that should be considered. So let's move on to the rest of the list. Additional sources might be reports from medical providers and other outside professionals, the CUME file, discipline and behavior reports or plans, functional behavior assessments, health wellness screening results, adaptive behavior assessments, and social and cultural background information. These are all important pieces of information that can be used, and it is not implied that you need to gather all of the listed documents to proceed with an evaluation. Again, remember that you need to just have a general information gathering process. It doesn't have to be highly specialized and critical. And this may help you to make a better decision when you're looking at eligibility for 504. This slide really serves as a launch pad for possible times to consider that there may be a need to evaluate a student for Section 504. So, for example, teachers may be feeling overwhelmed with where to start and with which students when they know there's something going on, but they're not quite sure how to consider what students need what services. These 5 different considerations may help us to make a better determination of whether or not we want to evaluate a student who may have an impairment that is substantially limiting to one or more of the major life activities. If one of these scenarios exist, the team would first want to dig a little deeper to see if there's an underlying cause of any of these that could be due to an impairment or condition that's limiting their ability to fully participate in school and school-sponsored activities at the same level as the rest of the students in the school. Students do not need to be failing to be referred for 504 evaluation. Looking at grades alone cannot be the sole reason to either refer or deny or delay a referral. So, while grades are an important piece of information to consider, they need, again, to be looked at in conjunction with other data points. Likewise, teachers who are feeling like they may have multiple students who may be in need of accommodations due to an impairment may need assistance from you as the administrator or the Section 504 coordinator at your school to help them prioritize all of the referrals. May also need to look at some systemic issues in the classroom if a teacher believes that many students may require a 504. So looking at trends in information is important. Also, we need to look carefully at children who are on health care plans. These children may be eligible under Section 504, Some healthcare plans are seen as a tool to reduce the negative effects of impairments such as diabetes, asthma, allergies, and as such, they can be mitigating measures. However, some students may not require a 504 plan just because they're on a healthcare plan. The best thing to do is to consult the school nurse when you're making those decisions. The legal expectation is that we will conduct child find and locate, evaluate, and determine eligibility for all students suspected as having a need for services. Prioritizing is one way to work through all of the children who are demonstrating a need but do not necessarily need to be taken all the way through referral and evaluation. Others we may need to prioritize as our first students who need to be evaluated. So look at these 5 bullets. Student doesn't respond to tiered intervention. There's a request for an evaluation for 504 plan. A student may be being suspended or sent to safe school, and that may be a reason to consider whether or not there's something substantially limiting a major life activity. Academic performance is lower than expected. Chronic absenteeism is another one. So these may just be starting points for you to look at whether or not a student may need more and may need to be considered under child find. Okay, in addition to the 5 starting off points that we talked about, there are a few more. If a student is evaluated under IDEA and is found not eligible and didn't meet the criteria for IDEA, they may be a student that we want to consider for 504 eligibility. Now remember, and many of you will remember this, that we've said for a long time that 504 is not a consolation prize for not being qualified under the IDEA. However, we still have the obligation to consider 504 eligibility separately from IDEA eligibility and consider the specific criteria associated with 504 and whether or not a student would be eligible under 504. A student may be exhibiting ongoing medical problems that are having a substantial impact on the student in the school setting. The student enrolls with a 504 plan from another district. We absolutely want to consider number one, implementing that plan, but if there needs to be more evaluation, we absolutely need to consider that. An impairment of any kind is suspected for any reason, you want to consider child find under 504. And the student was formally found not eligible due to mitigating measures. So for example, a student parent expresses that they had requested a 504 plan at the prior school, and the team indicated that, well, your student is on medication, so they're really doing quite well. That again, a mitigating measure cannot be, and we know this through the amendments to Section 504 in 2009, cannot be a reason to deny eligibility for 504. So it's really important to make sure that we consider those starting points when we're looking at 504 eligibility and evaluation. Okay, so let's talk about eligibility. First, the big question is, are there any automatic qualifying disabilities impairments under Section 504? And the legal answer to that is no. In and of itself, an impairment does not equate to a disability. It must substantially limit one or more major life activities in order to be considered a disability under Section 504. Okay, so in evaluating a student suspected of having a disability, it is unacceptable to rely on presumptions or stereotypes regarding persons with disabilities or classes of such persons. So really what this is a discrimination protection, right? So we're talking about students with ADHD. Every student in our school with ADHD does not qualify under Section 504. You have to look at each one individually to determine if their impairment substantially limits one or more major life activity. But in the next few slides, we'll talk about the case law and additional guidance that's come out from OCR and the Department of Justice that calls on us to very carefully consider all students who have disabilities for 504. So let's move on to those slides. Okay, so this is what I mean when I'm saying that while we're not allowed to say that an impairment in and of itself and one kind of impairment automatically qualifies a student for under 504, OCR guidance also provided us a different perspective in 2012. So let me read this. While there are no per se disabilities under Section 504, Title II, the nature of many impairments is such that in virtually every case, a determination in favor of the disability is made. Thus, for example, a school district should not need or require extensive documentation or analysis to determine that a child with diabetes, epilepsy, bipolar disorder, or autism has a disability under Section 504 and Title II of the ADA. So it kind of feels like we're saying two different things in one presentation here, and in some ways we are. Really, what this means is that we need to look at each student individually, and if a student comes with a diagnosis, you absolutely should use that as the launch pad to make a determination whether or not a student qualifies under Section 504. Okay, so basically it's a great screener. If there is documentation, it allows you to say, okay, checked off the first box. Now let's see if this student qualifies under Section 504 and then needs accommodations and services on a Section 504 plan. The team needs to work through the GSD process to determine if a particular individual meets the eligibility criteria. And we need to be careful to not assume eligibility based on a specific diagnosis. But for conditions or diagnoses listed, the analysis may be less cumbersome. So just in summary, because I know this one is confusing, we can't say that all students who have a healthcare plan need Section 504 accommodations plan as well, okay? We can't say that all students with epilepsy, bipolar disorder, all kids with ADHD qualify for 504 and need a Section 504 accommodations plan. But we can say that because we know of these disorders or these impairments, we are going to make a good faith effort in every case to determine whether or not a student does need a Section 504 plan. That's the key difference there. And here are just a few more that the Justice Department has added over years of case law. Deafness substantially limits hearing. Blindness substantially limits seeing. Intellectual disability substantially limits brain function. Partially or completing missing limbs or mobility impairments require the use of wheelchairs, substantially limiting musculoskeletal function. So these are some other examples that would trigger consideration for Section 504. They don't presume Section 504 requirement, but they presume that you should consider whether or not a student may qualify. And a few more: autism, cancer, diabetes, epilepsy, muscular dystrophy, muscular sclerosis, HIV, depressive disorder, bipolar disorder, PTSD, TBI, traumatic brain injury. OCD is obsessive compulsive disorder, and schizophrenia. These each substantially limit brain function. PTSD, if you don't know, is post-traumatic stress disorder. So while they may not automatically trigger Section 504, they should serve as a good screener for you to determine whether or not they may be an indicator of a need and one that needs to be evaluated. Remember that while it may appear that nearly all of the students that have impairments that we just reviewed would be eligible, the focus is on whether the impairment substantially limits one or more major life activities when compared to an average individual in the general population. In all of the cases that we reviewed, the focus is on the extent to which the impairment substantially limits that major life activity. Some students with the aforementioned disabilities may be eligible for services under IDEA as well. In this case, it's still child find, and you would simply follow the formal evaluation procedures that apply to IDEA. We have forms in the student support process forms that help you to walk through these steps. The student support process model visual is a good one to help you understand what to do and what data to review to do that as well. If the team suspects that a student may have a disability under the IDEA, they would discontinue the 504 analysis and move specifically into the requirements under the referral process for special education. And that would start with formal referral for special education and then all of the formal evaluation. Of course, you would want to use all the existing data that you've compiled under 504 if that's the case. And there's nothing wrong with moving from one to another. That simply demonstrates that the team is being comprehensive and thoughtful and guiding their decision-making process in a very specific decision based on the data they've gathered. So let's just kind of summarize the congressional intent of Section 504. The definition of disability shall be construed in favor of broad coverage of individuals under this act. So the intent, the congressional intent was really to have broad coverage of individuals and also to look less at eligibility and focus more intently on whether reasonable accommodations are provided. So you may have teachers who are saying that they're already implementing or willing to implement accommodations to meet the students' needs, and they're using a great deal of differentiated instructional strategies, implementing informal accommodations. They meet all students' needs, and why do we need to proceed with a more formalized process? The reason we do need to consider eligibility and then formalize 504 plans is that the intent of this law is not only to provide the accommodations a student may need, but also to provide students the protections of non-discriminatory actions based on their disability. A student only has their legal protections by a committee walking through the evaluation, walking through eligibility process, and then developing a plan and implementing a plan with signatures that protect them. Teacher-directed accommodations are fantastic, and we expect that all teachers are going to meet each student's individual needs in the way that each student needs those. However, some students will rise to the level of needing more protected accommodations, and informal teacher-directed accommodations alone won't provide that level of protection. Let's quickly review the steps in team decision making for eligibility and services. First, the team must gather data, document whether there is a physical or mental impairment. Next, the team must gather evidence, data, and documentation on whether the impairment is substantially limiting one or more major life activities at school or school-sponsored activities. If number 1 and number 2 are present, the student is eligible for Section 504 under the American with Disabilities Act protections. The team must then determine if the student requires accommodations. If yes, the team will develop a 504 accommodations plan. If no, the team will document the decision and no plan will be developed. The student remains eligible for protections for non-discrimination under the law, regardless of whether or not the team follows it through to a 504 plan. This process documents all of the decision making, and therefore it is important that you use the forms that we have and that are available for 504 eligibility and evaluation in order to specifically document all those steps and the decision outcomes. Child find is a required process of every public school. Child find is the process of identifying and evaluating any student who goes to our school or outside of our school who may be in need of services due to an impairment. The district deals with district-wide child find. You are responsible for child find within your own school. You need to know the district required process and how it's implemented at your school. And each educator in your school needs to know how to make a referral to the student support team in a timely manner. We cannot and must not wait for a parent to ask for a Section 504 consideration if we've been aware that there have been issues all along that have led us to believe that a student is in need or may be in need of services due to an impairment. The student support process flowchart on the next slide helps to better walk you through the steps of how to make the decision of child find. It's the expectation that all of your staff are aware of the policies and processes and procedures and that they're trained in the procedures. If we do that, we're on stable ground in the event that there's an issue raised. So take a moment to remind the staff at your school of the procedures, timelines, and who the contact person is if they need assistance. It's important to make sure that all teachers know who to go to if they have a concern and understand the process for intervention as well as child find at your school. Here is an overview of the student support process. And this process includes child find. You'll see down in the yellow rectangle near the bottom, but it's not all child find. So much of the student support process really operates at the Tier 1 and Tier 2 level and never gets to child find. But you'll see that once an intervention plan has failed over time and there is demonstration of a failure to respond to that intervention, then you may be making a child find decision. And you can see that there are 3 levels of child find decision. 504 referral being the one we place in the middle, in between continuing on with gen ed support and remediation or going to formal evaluation for special education. You will want to make sure that you apply any reminders when you review this with your school staff about your specific school processes and timelines. This is the Granite District student support process, but you may have some specifics in yours at your school that you want to remind your own staff about. All teachers and principals can support their SST process in their schools by providing information and data or gathering that data and information, and providing observation access as appropriate. If we need to observe a student, a social worker or a psychologist, or peer observation, or even the principal may be observing a student to help to gather information. This is all part of the SST process. And then another big part of the process is to implement different components of the SST process as needed throughout the evaluation. It's important to keep in mind that once we've determined that we need a Section 504 plan, we're not required to eliminate the impact of a student's disability, but rather we are required to develop plans that will minimize the impact to the best of our ability. The implementation phase of a Section 504 plan means that we are going to implement services that are adjustments designed to minimize the impact of the disability to meet the unique needs of a student. There's no list of approved accommodations. Those are to be determined individually for each student based on team problem solving and decision making. Many services are inexpensive and utilize good teaching practices and classroom management strategies or differentiation techniques. There is a large list of accommodation resources that we reviewed last year, and that's also going to be available for you in our training for you to use with your staff back at your school again. The accommodations resources list is not a checklist. Rather, it's a bank of ideas to start conversations and decisions to determine the types of accommodations that are required for the individual student's needs. So it's really to help you get your ideas kind of flowing, and then to help you kind of model the practice of using the data you have on a specific student to identify what their specific accommodation needs might be. Team discussions should be targeted and focused only to the accommodations that are needed to support the student. So we're not going to go through and check off everything that we think might be a benefit to the student, but those that are targeted to the student's specific needs. And the focus is to make the student as independent as possible. The accommodations do not provide more assistance or support than is needed to help the student to be independent and access their education. Many of the accommodations that teachers have been implementing prior to the formalized process will still be memorialized in the Section 504 plan. So there's no need for a teacher to abandon what they've been doing because now you're formalizing the plan, but rather it's to memorialize what's been working in the plan. It's important that once you've evaluated a student and determined that you will implement a 504 plan, that teachers participate in the process of developing the strategies. They need to have input into the plan because they already know the student, and they are going to have ideas for accommodations and strategies that will work in their classroom. The 504 plan is a legal contract between the school and the student. Teachers are responsible for implementing the designated services and strategies identified in the plan. Teachers do not have the discretion to decline or refuse to implement any component of the 504 plan. So it's extremely important that they have input. Only the team can make modifications to the plan. Changes are to be made based on the student's needs, not the convenience of school staff or the inclination of one individual at the school to implement or not to implement. There is no opting out of the obligation to provide the strategies and services that are memorialized in a 504 accommodations plan. If a teacher or another educator or staff member has a concern about the contents of a plan or strategies that are on a plan, if something's not working, or if they feel there's a need to revise, then the only thing to do is to discuss the concerns with the Section 504 coordinator and case manager, and then reconvene the team to make adjustments if found necessary. Again, while the implementation phase is in effect, Teachers should collect data and information regarding the implementation of the strategies. Teachers then provide input, feedback, and recommendations and other critical information during the annual review of the plan. If we don't have data or feedback regarding plan implementation, it is a red flag that either the plan is not being implemented, or certain people have been left out of the loop. The questions we want to ask in monitoring a Section 504 plan are these. Does the impairment continue to substantially limit a student's participation in the school, academic or extracurricular? Are the services utilized by the student? Are the services actually being utilized? So that's one thing that a teacher really can keep data on. So we've made these services or strategies available, and we have this in place, but the student never uses it. If that's the case, then you want to give that feedback to the team to determine whether or not it's something that should be included in the 504. 504 plans should be targeted to what the student specifically needs to help them mitigate the effects of the substantial limitation of a major life activity. So if they're not utilizing something, then it's either not working and we're not mitigating and we need to try something else, or the student didn't need it in the first place. Are the services effective? So if it's not working, you want to go back and look at what isn't working about it. How can we change it? Or do we have data that the services were actually implemented as articulated in the plan? If the services were not implemented appropriately, we can't say they didn't work. We need to say there's a fidelity of implementation problem, and we need to go back and help individuals to implement with fidelity. Then, does the plan need to be changed? And are there other factors such as poor attendance or failure to turn in assignments that are affecting the student's success? If that's the case, we need to go back and consider whether or not there's something we need to revise in terms of the plan, or if it's something that falls outside of the student's need. So in conclusion, appropriate education, as included in the definition of a free appropriate publication, is the provision of regular or special education and related services that are designed to meet the individual education needs of students with disabilities as adequately as the needs of students without disabilities are met. Schools must provide the student with a FAPE under Section 504. The law does not require the public school to provide students with disabilities with potential maximizing education. We must provide reasonable accommodations that give eligible students the same access to benefits of public education as all other students. We hope this module will serve as a foundational resource for you and your school teams to understand the specific requirements associated with Section 504. If you need any further assistance, contact your school Section 504 coordinator. Make sure you access your school SST, your student support team, and understand the process, and then review the GSD Section 504 resources that are on the Educational Equity site or under the Administrator Resource site through the intranet. As always, you can call Educational Equity at the number listed. Thank you.